CR 5859, State of Texas versus Thomas Henson. Can I have parties approach and announce for the record for the state?
What you're about to witness is one of those courtroom moments that starts routine, paperwork, plea confirmations, legal formalities, and then suddenly transforms into a powerful reality check delivered straight from the bench. And trust me, this case hits hard because it's not just about law. It's about family, accountability, and how one bad decision can snowball into life-changing consequences. Here we have 18-year-old Thomas Henson, charged with aggravated assault with a deadly weapon, a serious felony in Texas. The victim? Not a stranger, not a bar fight opponent, his own stepfather. And the altercation allegedly began over money, after Henson insulted his own mother and escalated things into violence. Now here's the twist. Instead of immediate prison time, the court is considering deferred adjudication, essentially probation with conditions. If he succeeds, he could avoid a felony conviction. If he fails, he could face up to 20 years in prison. So the stakes here are enormous. Watch closely how Judge Boyd handles this. She doesn't just recite legal language, she starts asking real questions about responsibility, maturity, and life choices. And what unfolds becomes less about technical legal procedure and more about whether this young man is going to turn his life around or dig himself deeper. And here's something to think about as we begin. At 18, when does family support turn into enabling? And how much responsibility should a young adult carry for their own actions? Stay with us, because this courtroom exchange gets intense, personal, and surprisingly emotional as we move forward.
Caller for the state.
For the defense? And are you Mr. Henson? Defense, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case, and did you review that with your client?
We have, Your Honor, and I have.
Court will find that the state is in compliance with discovery. Mr. Henson, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Henson, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine. Did you understand? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Henson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's to be a $500 fine. There's an affirmative finding of deadly weapon. State recommends deferred adjudication. They will take in consideration the following county court cause numbers: 664-461, 664-462, 71781. And there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the entirety of the agreement? Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 4 years. There be 240 hours of community service restitution, TAP evaluation, no harmful or injurious contact with Avilio Walters Torres, that's AVILIO, no firearm possession, hostility, and aggression control course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Judge. State would offer what's been marked as State's Exhibit number 1.
No objection.
Mr. Henson, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty.
This is the turning point where courtroom procedure gives way to personal accountability. Up until now, everything has been legal mechanics, plea agreements, evidence stipulations, waivers. But once the judge begins sentencing discussions, the human story behind the paperwork emerges. Judge Boyd has already read the police report, and she knows exactly what happened. A late-night visit, an argument over money, disrespect toward his mother, and then violence against a parental figure. And judges see patterns: entitlement, anger management issues, lack of direction. All signs that without intervention, this case could escalate into something worse down the road. Here's the key legal insight. Deferred adjudication is not leniency, it's opportunity. The court is basically saying, we won't formally convict you yet, but you must prove you deserve freedom. And that opportunity comes with strict rules: curfews, counseling, job requirements, and supervision. And notice how the judge keeps circling back to work and education. Courts often see unemployment and lack of structure as risk factors for repeat offenses. Stability matters. Let me ask you, if someone insults their parent and then assaults a step-parent defending them, should that person get a second chance or immediate jail time? Because the judge is about to dig into this young man's life choices, and things get uncomfortable fast.
Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
No, at this time, Your Honor.
All right, how old are you?
18.
18? So why are you beating up your stepfather? And mind you, before you speak, I've already read the police report.
I was
You need to speak up. I can't hear you.
I was just not in my right. I was kind of following like a very,
I can't hear you. Open your mouth and speak so I can hear you.
I have kind of like an issue, and I went about it the wrong way.
No, because I read the police report. What your issue is that you went to your mom's house where she lives with your stepfather. You asked your mom if she could stay, and you came over there early morning hours. Then you asked your mom for money, and it appears she did not want to give you money. So then you called her the B word, and then your stepfather said, don't speak to her that way. And then you proceeded to beat him up. So what was the issue? No, what was the issue? Because people, when you ask people for money, they can either say yes or no. So your mother said no. You called her the B word. Why are you calling your mom that word?
I shouldn't have done it.
No, I know you shouldn't have done it, but my question for you is, why did you?
I lost my temper.
Temper what? Because she wouldn't give you money that was her money? Is that what you lost your temper over? The fact that she said, no, I'm not giving you any money? Do you have a job? So if you want money, and this is what I don't understand about some young people, if you want money, then guess what? You get a job and you earn it. Your mom, your father, your stepfather, your brother, your cousin do not have to give you money. You're of age. Are you in school? So basically you're doing nothing with your life because you're not in school. Do you have a job? So you're not in school, you don't have a job, you're doing nothing with your life, and you expect your mother to support you.
This moment is raw. Judge Boyd stops talking like a legal official and starts speaking like someone trying to wake a young person up before it's too late. And honestly, this is where many viewers feel divided. On one side, critics say judges should stick strictly to law, not life lectures. On the other hand, supporters argue that sometimes young defendants need blunt honesty, not just legal consequences. Legally speaking, the judge is evaluating risk. No job, not in school, relying on family support, recent violent conduct. These factors suggest instability. Courts consider whether someone is likely to reoffend, and structure is key to preventing that. But emotionally, this hits harder. The judge is confronting entitlement, expecting money from parents, reacting with anger when denied, and then turning violent. And those patterns often lead repeat offenders back into courtrooms. And here's a tough question. At what point does personal responsibility override childhood or environmental excuses? Everyone talks about the wrong crowd, but as the judge points out, sometimes you are part of that crowd. Do you think Judge Boyd is being too harsh? Or exactly what this young man needs to hear? Because now the family dynamic enters the courtroom, and that adds a whole new layer to the story.
And you want money, and when she tells you no, you call her a B. Where are you living?
My grandma's.
And how are you treating your grandfather? And does your grandfather even want you there?
Yes, ma'am.
Judge, he has a job interview this week. His grandfather is present in the courtroom today. He is very involved in this case and he does support my client, and he does want him in that house, and he has done everything he can to ensure that his grandson is taken care of at this point in time.
Do you have children? If you're drug tested today, what are the results going to be? What are you doing with your life other than not working, not in school, calling your mom the B word, and beating up your stepfather? Other than that, what are you doing with your life?
I have ambitions to change my life for the better, Your Honor. I do want to work at a college. That's where my interview is going to be at. And I want to get my GED so that way I could further go to a trade school and become a mechanic.
How far did you go in school?
I made it to 9th grade.
Why did you drop out?
I fell into the wrong crowd. And
Nope. Let me just tell you something about the wrong crowd. If I had some other person standing up before me and they said they fell into the wrong crowd, and I asked them, well, who's the wrong crowd? You know what they're going to say? You are. So I don't want to hear this nonsense about I fell into the wrong crowd, because if you are with the wrong crowd, then you are in that subset of wrong crowd, and you're a part of the wrong crowd, and you are the wrong person. You understand? Let me see his grandfather. Hello, are you his grandfather?
Step grandfather, yes.
Step further. Could you raise your hand for me, please? Do you solemnly swear the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Could you state your name for the record?
Michael Andrew Mirchuk,
Okay, I'm sorry, spell your last name.
Mierchuk.
All right, so you're the step grandfather. Is your son the stepfather of him?
No. I
Okay.
mean, my wife is that's his her.
So your wife is his biological grandmother. Okay. So here's the thing. Does he have rules at your home?
Yes, he does.
All right, and what are those rules?
Right now, especially with the monitor on, he can't do anything. We monitor, we basically told him that once the monitor comes off, the rules are going to be no drugs, no nothing. He's going to get a job. He's going to get his, we're going to get him into the GED program, figure that out some way. And hopefully from there, we're going to make sure he gets better.
All right, and what is his curfew at your house?
He hasn't really had to have one right now, but we're going to stipulate one 10 o'clock at night.
Okay. All right, is there anything else that he needs to do at your house? Do you need him to help clean up? Is that part of his?
Chores are going to be, he's already doing chores, and his grandmother's already set the rules for what she wants him to do as far as clean up, laundry, things like that for right now, until he gets his supposedly Friday tomorrow. He's got the job interview, and hopefully he'll get the job, and we'll work from there after that.
All right, so you're aware that he did beat up his stepfather.
Yes, ma'am.
All right, so is there any fear with him being in the house?
No, ma'am.
All right, you all know who to call if there's an issue?
Yes, ma'am.
All right, and I'm assuming, I guess, the GPS, you all have been paying for that? Oh, it was waived? Okay.
Yes, Judge, it's kind of an interesting situation when they impose that GPS monitor. He lives within, several hundred yards of the complaining witness in this case.
This section reveals how complicated family cases can be. The defendant isn't dealing with strangers, he's surrounded by relatives trying to help, yet those same relationships contributed to the conflict. Legally, GPS monitoring is about accountability. The court isn't just punishing behavior, it's managing risk. By placing Henson under strict curfew and monitoring, the judge ensures he's not putting himself or others in situations that could lead to another incident. But notice the balancing act. The grandfather supports him, gives him housing, and believes he can change. Courts often rely on family support systems to reduce repeat offenses. However, support without discipline can sometimes backfire. The judge's warning is clear. 1 minute late could land him back in jail. And this is probation's reality. Small mistakes carry huge consequences. Here's a question for you. Do strict conditions help people reform, or do they set them up to fail? Because probation success often depends on whether someone truly changes habits, not just follows rules temporarily. And coming up, Judge Boyd lays down the full list of conditions, and they are extensive.
It's just a family dispute. He was not permitted to move in with his grandfather until yesterday, actually, is when we were able to do a carve out from the protective order. So my client had been residing at a short stay hotel, and his grandfather was going over to visit him and take what he needed because he was on house arrest.
Okay, well, he's gonna remain on GPS, and I'm gonna give him a 10 PM curfew. So you can go out, do your job, interview for jobs, he can do chores, but he needs to be back at his grandfather's house at 10 PM, no later than that. If you are 1 minute late without informing probation, what's gonna end up happening is the motion to revoke is gonna be filed against you, and you're gonna come over to court dressed in orange if you can't make bond, and we'll hear the reason why you're late. Do you understand? All right, thank you so much for taking him in.
Your Honor, if there's no violations, let's say within 90 days, would the court entertain a removal of the GPS?
I'm always willing to entertain whatever motions people bring before me.
Okay.
All right, thank you. Thank you so much.
And for clarification, this is tracking only, but he is going to have.
He has a curfew of 10 PM. All right, this is what the court is going to do. It's going to be 4 years deferred adjudication, $500 fine, that will be probated. Take in consideration county court cause number 664461, 664462, 671781. There's an affirmative finding of a deadly weapon and family violence. There's 240 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but you have it, including the booster. The court will consider, will allow you to waive 40 of those hours. The remaining hours will be waived if you provide proof of your GED. You must pass that. Do you understand?
This sentencing breakdown is where viewers sometimes lose focus, but it's actually one of the most important parts of the case. Community service, employment proof, education requirements, aggression counseling, these aren't random conditions. They're targeted corrections. Courts try to fix root causes: lack of education, anger control issues, unstable employment, and poor decision making. And notice the incentives: hours waived for completing GED or vaccination proof. Courts sometimes use incentives instead of pure punishment, encouraging constructive behavior rather than only penalizing mistakes. The restriction from working with minors or vulnerable populations is also key. Courts consider public safety when assigning employment restrictions. Here's something interesting. Instead of sending him to jail, the judge is essentially designing a rehabilitation roadmap. But whether he follows it depends entirely on him. Let me ask you, do you think structured probation programs actually change behavior, or do most people end up back in court anyway? Because unfortunately, this case isn't over yet. And what happens next shows how fragile second chances can be.
There's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be, of course, no firearm possession. We're going to do the hostility and aggression control course. There's a 10 p.m. curfew. So probation, outside of work, if he's not at work, he needs to be back in at 10 p.m.
Yes, Your
He's
Honor.
allowed to be outside the house from 7 a.m. to 10 p.m. only. Now, if, like I say, if he has employment and his work schedule is later than that, but he's saying he's working at a car wash, and I know the car wash is closed probably at like 6 p.m. There's to be field visits 2 times per month. And let probation know to check on the grandparents to make sure that everybody is enjoying Mr. Henson's stay. And he's to reside with his grandparents. There's to be no contact with Avilio Torres. If you want that changed, Mr. Torres is going to have to come in.
Your Honor, he's already signed an affidavit of non-prosecution. We've already discussed it on the civil side for their protective order. And we did have the bond already changed to no harmful or offensive contact, but if you.
I'm not doing no harmful or injurious contact because I know what ends up happening. He's married to his mom. He's trying to make the mom happy, but the person before me beat up, and I don't know if it's a senior citizen or not, but he beat up someone who's in a parental role, and that's a big no-no. So if that's going to be lifted, then Mr. Avilio Torres needs to come in here. I'm going to look him in the eye and see and determine whether or not he's doing this just because that's his wife's son. But I have a big concern with a child who's 18, 1, calling his mom the B word, and 2, beating up the stepfather because he tells him, dares to tell him, do not speak to your mother that way. That's a problem. He's all nice and polite to me right now, but I don't know what's happening in that household. So there's to be no contact with Avilio Torres, and you can tell the family that Judge Boyd said that he is not to have any contact with him. And it's not Avilio's fault. I know. And for the record, I'm going to say that Avilio filed a non-prosecution.
This moment highlights the judge's protective role. Even though the victim signed paperwork suggesting he didn't want prosecution, the judge refuses to lift the restriction. Why? Because courts often see victims recant or minimize incidents in family violence cases, especially when emotional ties exist. Judges must think long-term safety, not just immediate forgiveness. Judge Boyd's concern is clear. Violence toward a parental figure suggests unresolved anger issues. And reconciliation without real change could lead to future harm. And her comment about only having one mother? That's where law meets life advice again, reminding viewers this case isn't just paperwork, it's broken relationships. So let me ask, should courts respect a victim's forgiveness or enforce restrictions regardless to prevent future harm? Because fast forward, and we'll see what happens when probation
And
conditions
that I
aren't fully
know
followed.
that it's been lifted on the other side, but I'm not lifting it here. So you don't have any contact with him. You understand?
Sure.
And if I decide to lift it at some point in time, you had better have your letter of apology and sincerity in that letter for him and for your mom. You only get one mom, you understand? So there's to be no contact with Avilio Torres. There's to be regular UAs. And there's to be regular reporting by Zoom or in person. Probation, is there anything else he needs? Is there anything else you need from me in order to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Good luck to you. Here's the thing. You better start treating your moms right. Moms don't last forever. They're not going to be on the planet forever. Don't be that person who's in an imitation of life, running behind a coffin after you had treated your mom so badly, because people are not going to be sympathetic towards you. You understand? All right, good luck to you. Probation is going to go over your condition. Are you all ready to proceed on the motion?
Yes, Your Honor.
Yes,
All right, is this going to be contested or no?
No, Your Honor.
And here we are, the sequel nobody hopes for in probation cases. Same defendant back in court, now facing potential revocation of the second chance he was given. This hearing happens after new allegations of assault while on probation. That's critical. Probation isn't freedom, it's conditional liberty. Violating conditions means the court can now impose the original sentence. By pleading true, Henson admits the violation. Legally, that opens the door to up to 20 years in prison. Everything now depends on whether the judge believes rehabilitation is still possible. And viewers often wonder, why give repeated chances? Courts struggle with balancing punishment and rehabilitation. Lock someone up too early and they might never reform. Wait too long and someone could get hurt. So here's the engagement question. After violating probation once, should someone automatically go to prison or deserve one more attempt at treatment? Because Judge Boyd now faces a tough call.
All right, I don't have I do. All right, the court is calling 2022 CR 5859, State of Texas versus Thomas Nathaniel Henson. Can I have parties announced for the record for the state,
Zach Dunn for the state.
for the defense?
Catherine Valenzuela.
Are you Thomas Henson?
Please remove.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement motion to enter adjudication of guilt and revoke probation. Did you review those documents with your attorney? Did you understand them?
Yes.
Are you the same Thomas Nathaniel Henson who was placed on deferred adjudication in 2022 CR 5859 for the offense of aggravated assault with a deadly weapon on September 15, 2022 for a period of 4 years?
Yes, ma'am.
State?
Your Honor, on or about the 11th day of August 2023 in Bear County, Texas, the defendant, Thomas Nathaniel Henson, committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
State?
And Your Honor, there's an agreement.
The other allegations?
There are none, Your Honor.
Are you waiving?
Yes, Your Honor.
All right, any objections to the waivers?
No objection to the waivers. Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yeah.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Your Honor. We had an agreed recommendation to continue and for DDRF.
This is a critical fork in the road for the defendant. After admitting to violating probation through another assault allegation, the court could immediately impose a prison sentence. Legally, once he pleads true, the judge has full authority to revoke probation and send him away for up to 20 years. That's not a threat. That's real sentencing power. But instead, we see negotiations and recommendations for treatment alternatives. This tells us something important. Probation officers and attorneys believe there may still be a rehabilitation path available, possibly through structured intervention rather than incarceration. Programs like DDRF or ISF aren't vacations. They're intensive treatment environments aimed at addressing behavioral or mental health factors contributing to criminal conduct. The courts use them when they think the issue isn't just criminal intent, but deeper instability or untreated issues. Judge Boyd's questions signal hesitation. She wants assurance that whatever option is chosen will actually address the root problem, not just delay another violation. This is the justice system's toughest balancing act, protecting the public while still offering rehabilitation when it seems possible. And viewers might wonder, how many chances should someone get before consequences become permanent? The next exchange reveals even more about what went wrong during probation.
That is understanding, Your Honor.
All right, probation, is that your recommendation?
Yes, Your Honor.
What is the wait time for DDRF? The wait time is 6 to 13 weeks. Do we have any other alternatives?
State ISF cognitive track, Your Honor, that wait time.
All right, but will that address the issue? Because DDRF, I'm assuming there's a mental health issue.
And Your Honor, that had been the first recommendation, then he did the tap about, and that's why we got to NDRF, but the first recommendation had been ISF cognitive.
All right,
Sorry.
no problem.
So yes, the original recommendation was for the state ISM cognitive track, but we did an updated TAP while he's been in Bear County, and the recommendation changed for DDRF due to the mental testing.
All right, so the new number one, who is the complainant? I mean, what is the relationship?
She's been my girlfriend.
Girlfriend. All right, and are we doing no contact with the girlfriend?
I believe there had been, she did sign an affidavit of non-prosecution. We did enter plea to proceed with the treatment that he believes he does need, Your Honor.
All right, so I'm going to order no contact with that person. And then once his mental health is stable, we'll do something different. Do you understand?
This part shows how personal relationships can derail probation success. The new assault allegation involves his girlfriend, and the judge quickly moves to impose a no-contact order. Even though the girlfriend reportedly signed a non-prosecution affidavit, courts often override those wishes in domestic situations. Why? Because victims sometimes retract accusations due to emotional pressure or dependency. Judges prioritize safety over reconciliation. Then comes another recurring theme: instability at home. Henson was living with his grandmother, yet inviting others to stay without contributing financially or maintaining stable employment. From the court's perspective, this shows immaturity and poor judgment. Red flags for probation success. Judge Boyd's frustration isn't about romance, it's about responsibility. Bringing chaos into a supportive household risks repeating the same cycle that landed him in court in the first place. And here's something viewers should consider. When someone is on probation, every decision, relationships, housing, employment, becomes part of their legal survival. Because next, probation officers explain why they're worried history might repeat itself.
I'm sorry, you need to speak up. All right, so do you have anyone else that you can live with? Mother?
I wasn't just living with her. She was living. She was staying.
Okay, you're mumbling. I can't understand. I can't hear you in the court report. I can't hear you.
I wasn't living with her. She was staying with me. So.
All right, so do you have your own place? So who were you living with?
Yes, I was staying with my grandma.
All right, so you need to stop inviting people to live with your grandmother when she's already have you living with her. You understand?
And
So were you supporting yourself at all? Or were you just dependent upon your grandmother?
I mean, I wasn't paying rent, but I wasn't.
Were you working? I'm sorry, I can't hear you.
Sometimes.
So that means that you're not bringing in a stable income and you're bringing somebody else into your grandmother's house. That's a big no-no. You understand?
Yes.
All right, probation, anything with Center for Healthcare Services or?
Your Honor, I think. And I know that the state waived and abandoned the other allegations. However,
This is the probation officer's reality check, and it's devastating for the defense's argument. The officer lists multiple warning signs: failure to report, positive drug tests, unfinished anger management programs, and eventual absconding. From a legal standpoint, probation is actually easier than incarceration. Show up, follow rules, take programs seriously. But failing even these basic requirements tells the court that the defendant isn't prioritizing the opportunity he was given. Notice the judge's blunt question: do you want to go to prison? It sounds rhetorical, but legally it isn't. Because actions, not words, determine outcomes in probation cases. What makes this tragic is how preventable it seems. Reporting to probation is one of the simplest conditions, yet skipping it signals disregard for court authority. And this moment forces viewers to ask, Are these repeated failures due to immaturity, addiction issues, or simply refusal to take responsibility? Because despite everything, Judge Boyd still considers one more chance, and that decision surprises many watching.
He last reported to probation in March. So that's a concern for us. Right before he absconded, he did produce one negative UA, the others were positive. He did not complete his hostility management course that was originally mandated. I think our concern would be that he would abscond again without actually getting the help that is necessary.
All right. Do you want to go to prison? Because we can do that. Then why are you behaving as though you want to go to prison by not reporting? That's the easiest thing on the planet to do. You're obviously not working, really. So you're just watching television with your grandmother or something, or putting a burden on her where she has to feed you, and then you're bringing a girlfriend into the house. That seems like all you were doing and not doing well on probation. Do you want to go to prison for up to 20 years? All right, this is what I'm gonna do. I'll deny the motion. There's to be no contact with the complainant, whatever her name is, give that to probation. So the complainant and condition number 1.
Here's the twist many viewers don't expect. Instead of revoking probation and sending Henson to prison, Judge Boyd denies the motion and orders placement in a structured cognitive treatment program. Legally speaking, this is a massive break for the defendant. Many judges would have imposed prison time at this stage. But Judge Boyd clearly believes treatment, not incarceration, is still the better path, provided he actually commits this time. ISF cognitive programs are designed to address thinking patterns that lead to criminal behavior. They're intensive environments focused on decision-making, impulse control, and responsibility, not punishment alone. But notice the judge's tone. Patience is running thin. This isn't forgiveness, it's conditional mercy. One more serious violation could mean immediate prison. And this decision sparks debate among viewers. Some feel repeated chances waste court resources. Others argue rehabilitation prevents future crimes. What do you think? Should the system keep trying to reform someone this young, or does accountability require harsher consequences now? Because the judge's final conditions show just how serious this last opportunity is.
You are not to have any contact with her. Do you understand? So as far as your probation is concerned, that relationship is over. Do you understand? Do you have any children with her? So that relationship is over. If you end up violating my order and having contact with her, you could potentially go to prison for 20 years. Do you understand? And we're going to do state ISF cognitive and substantive track. And then we'll see where that leaves us.
Okay, Your Honor, I do want to point out that the way that state ISF is being ran now, it's not a double track anymore. It's either one or the other.
We'll do cognitive.
Thank you, Judge.
And then after that, when he's released, we'll put him on GPS, partial for work, until further notice. And you to reside at your grandmother's house. You understand?
Oh.
And Your Honor, for Mr. Hanson's benefit, what are you looking for, or what is the court looking for so that he could get off GPS? I mean, just so that he knows, like, if he's always reporting, attending.
Now, the court outlines the roadmap moving forward, and it's clear the margin for error is gone. After treatment, Henson will be placed back on GPS monitoring and must live with his grandmother under strict supervision. Judge Boyd explains exactly what success looks like: consistent reporting, program completion, stable employment, and 0 violations. No ambiguity, no excuses. The message is simple: take probation seriously or prepare for prison. What stands out is how the judge connects behavior to consequences. She wants him to understand that every missed appointment or bad decision moves him closer to a 20-year sentence. Courts often feel frustration when defendants treat probation casually because each violation consumes resources and risks public safety. At this point, probation becomes a test of discipline and maturity. And it's no longer about mistakes, it's about choices. And viewers watching at home might wonder, Can someone who has struggled repeatedly finally change when everything is on the line? Because now, as this hearing concludes, we step back to look at the entire journey of this case.
Oh, he needs to show me that he's actually taking this probation seriously.
Okay.
If you're not taking it seriously, what's going to end up happening is a motion to revoke is probably going to be filed. And instead of you worried about GPS, you'll be looking at potentially 20 years in prison. Do you understand?
Yes.
All right. And see probation if those fees can be waived.
Same here.
All right, thank you.
Let's step back and look at the full picture of this courtroom saga. What began as a violent family dispute involving an 18-year-old quickly became a test of whether rehabilitation or punishment should define his future. Judge Boyd, throughout both hearings, balanced legal duty with personal accountability. She granted deferred adjudication instead of prison, imposed strict conditions meant to create structure, and, even after violations, chose treatment over incarceration one more time. The final ruling leaves Henson under probation with treatment requirements, strict monitoring, and the understanding that any further violation could mean up to 20 years behind bars. The broader lesson here goes beyond one case. Courts can offer opportunities, but they cannot force change. That responsibility lies with the individual. And this case also highlights how family conflict, unemployment, lack of direction, and anger issues can spiral into criminal consequences when left unchecked. The justice system tries to intervene before things become irreversible, but success depends entirely on the defendant's choices. And now we want to hear from you. Do you think the court made the right decision giving him another chance, or should prison have been imposed after the violation? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.